Andrew Weissmann and Lisa Rubin are back with me. Lisa, so much legal news for both of you. Thank you for being here. Pecker clearly was first for a reason, and you both have been part of the strategy of this. Now, having heard it, how did he lay the groundwork for the prosecutor's case as we look to the next stage?
Brilliantly, I'll say, and that has a lot to do with the homework that the Manhattan DA's office did. But remember, Jen, this case is not so much about the hush money scheme as it is about falsification of business records, 34 counts of it. But what makes it a felony is that it was done to either with the intent of concealing or committing another crime. And what Pecker did was establish that other crime, namely a conspiracy under New York election law to promote or prevent the election of a particular person through unlawful means where one or more acts were taken in that direction. Pecker laid all of that groundwork, the formation of the conspiracy, the unlawful means, meaning the Karen McDougal settlement payment and the way in which it was orchestrated, and then thirdly, the fact that the unlawful means here was not only the agreement, but the fact that they had sort of larded it up with services, an attempt to skirt campaign finance law. In other words, he knew that paying her off to suppress her story with the goal of promoting Trump's election was unlawful. And so what he did was, in that agreement to purchase up her story, also provided that she would do columns for the National Enquirer or serve as red carpet interviewer for Radar Online, one of their properties, and the like. That was all a ruse, although a ruse that Karen McDougal herself took very, very seriously. And that's what posed problems for them eventually, because she wanted them to make good on that portion of the agreement. And really, they had done it all along to silence her.
I mean, the Pecker testimony was so interesting. A lot of it was, I can't believe this all happened this week. I wanted to just go in reverse before Pecker, Andrew, and ask you about Todd Blanche's opening statement. This all happened this week because he made some pretty bold statements in their hearing, just even as a non-lawyer. He basically denied Trump's alleged affair with Daniels. That's not a part of the legal argument or necessary in the legal sense, but does that matter? And how could that come back to bite him, or if it could?
So one of the things when you are on trials, when you are either the prosecution or the defense, you need to be extremely careful about what you promise a jury. And what happens is both sides listen very carefully to that, and it will come back. If you have promised something that did not come to play, then you are going to hear that. So the statement that denying the tryst with Stormy Daniels, I'm not really sure how that is going to come into evidence, because Stormy Daniels, if she testifies, is clearly going to say it happened. Donald Trump, who I think everyone thinks is not going to testify. I'm sure the prosecution would love it if he did. But for the same reason he never met with us in the Mueller investigation, I think there's no way in God's green earth that he is going to testify. So I don't know how that is going to come into play. As Lawrence O'Donnell has said, that's the kind of thing where it may be that Todd Blanche felt he had to say that for his client, but it is
like
going
the pressure.
Exactly, that he needed to say it for the public consumption, but at trial, it is going to hurt him if he doesn't prove it up, because in summation, you are going to hear the state saying, this is what he told you. That is not true, and the message being that don't trust him. So it's very, very important what people say in openings. Obviously, it remains to see what the jury makes of all of that.
Yeah, everything that's happening. So, Lisa, one of the things we learned this week, there's text and email exchanges for all of this, some of which we learned about this week. We learned about a text message that Dylan Howard, the top editor of The Inquirer, sent to a relative on election night saying, quote, "At least if he wins, I'll be pardoned for electoral fraud." Judge Merchan, if I'm correct here, won't allow it in evidence, but doesn't that make it really clear that they knew this was illegal?
I think it absolutely makes it clear that not only did David Pecker know that it was illegal, but that Dylan Howard had figured that out as well. And Jen, I should say, this is sort of a close call from an evidentiary perspective, because most times statements of a co-conspirator can be admitted into evidence. On the other hand, as Mershon reasoned, this was a statement that he didn't make to another member of the conspiracy, but rather was making to a first-degree relative. And moreover, Dylan Howard is not coming to this trial to testify. He lives in Australia now. David Pecker revealed in his own testimony that he understands that Dylan Howard has some sort of health problem that makes it untenable for him to travel. And so on balance, Judge Mershon decided that this would be too explosive to expose the jury to. But if you read the transcript and the sidebar between the lawyers where they're talking about the text messages from Howard to that first-degree relative, there is more of where that's coming from, a lot of other statements that indicate that Howard fully believed that Karen McDougal was telling the truth on election night, was horrified to see what had gone down. If those statements had come into evidence, I think it would have just been one more notch in the DA's belt with respect to proving up the existence of the conspiracy and the understanding on the National Enquirer's part that this was not only wrong, but unlawful.